All right, welcome everyone to our webinar today on redundancies and restructuring. My name is James True. I'm the practice group leader of LegalVision's employment team, and I'm here today with Sophie Joselyn, and she's a senior lawyer in our team. Now, before we start, we'd like to commence with an acknowledgement of country. LegalVision acknowledges and pays respect to the past, present and emerging traditional custodians and elders of this nation. In particular, the Gadigal people of the Eora Nation, whose land LegalVision's headquarters is situated on, and the various lands on which those of you are joining us today. Before we begin, just a couple of housekeeping items. You're going to be emailed a copy of this webinar recording. Throughout, you'll have the opportunity to submit questions. So there's a chat box for you. You can pop your questions into. We won't deal with them on the run, but we've got an opportunity at the end to take your questions and hopefully get through everyone's. And then finally, at the end of the webinar, we'd be very grateful if you can complete the survey. That's super helpful for us so that, you know, we're doing lots of these. We want to make them relevant and engaging. So your feedback's really important to us so that we can make them better. So without further ado, we'll just get straight into it. What we're going to be talking about. Number one, we'll cover reasons for redundancy, so actually why you might make a role redundant. We'll talk about the risks, because there are risks when you go through a redundancy. Sophie's going to talk us through what a genuine redundancy is, and ultimately that's something that you can do to ensure that all the risks are as low as possible throughout the process. We'll talk you through the process of actually carrying out a redundancy, as well as the entitlements, so what employees actually get when they are made redundant. Have a chance for the Q&A, and then we'll speak briefly about membership with LegalVision, and then how you can access a free consultation with us for having been a member at this webinar. So let's jump into it. In relation to reasons for redundancy. And this is really just talking about redundancies generally. A redundancy is when you are getting rid of a role. So when you no longer require a role to be performed by anyone. The reasons why an employer might make an employee's position redundant, they're things like automating a particular process. You might do that through a piece of technology, software. Very commonly and probably relevant at the moment are things like a downturn in business where you're ultimately just going to need to get your payroll costs down. Or otherwise, you might be getting rid of a role when you're looking at outsourcing duties, so getting a third party to perform the work that's being done by your employees. And then other just general changes in your business operations, which you might want to implement purely for the reason of efficiency. It's really important to get redundancies right. There are a lot of risks which we're going to talk about. One of the critical things that you need to remember for redundancy, and it's a very common thing for employers to do, is that they conflate redundancy with getting rid of someone's role, and they use it in the context of realistically in lieu of performance managing someone. So the general principle is that redundancies are not there to get rid of roles that employees aren't performing well. They're usually unrelated to performance. And so it's not the case that, well, we didn't want to manage someone, so we decided to make them redundant. Generally, and you'll see as we talk through the risks, that's going to pose a problem to you. But generally speaking, performance can be relevant in a redundancy. We'll talk about that as well. So if we move on, we'll talk about the risks on termination. Now, the primary risk when you terminate someone for a redundancy is that they'll file an unfair dismissal application against the employer. Not every employee can bring that claim, and there's criteria that they have to meet in order to be able to bring the claim. So they have to be employed with you for either 6 or 12 months. So it's 12 months if you're a small business, which is a business with fewer than 15 employees, and 6 months if your business is any larger than that. So that's number one for the criteria. They also have to earn less than the high income threshold. Now that amount changes 1 July every year, but it's currently 160,000. So if they're over that, they're not going to be able to bring an unfair dismissal claim unless they're covered by a modern award or an enterprise agreement. Most employees earning over that are probably not covered by a modern award or an enterprise agreement, but they can be. So the first thing always is understand whether or not the person you're making redundant can actually bring an unfair dismissal claim. Now, there is a defense to an unfair dismissal claim, which we'll run you through, and it's called a genuine redundancy. If the termination is a case of genuine redundancy, then the employee doesn't actually have jurisdiction to bring an unfair dismissal claim. So they can't actually even bring the claim if what you've carried out is a genuine redundancy. We're going to talk about exactly what it is and how to make sure you carry one out. So this is a great defense for your primary risk, which is the unfair dismissal claim. Carrying out a genuine redundancy doesn't mean no claims can be brought against you, so there are still risks. Another common claim that employees can bring on termination would be a general protections claim, which is really a discrimination claim or a victimization claim. So it might be something like, you picked me for redundancy, because I recently disclosed I was pregnant, or because of my religious views, or because I recently made complaints about my manager, and now you're making me redundant to get rid of me. They're fairly common claims to see as well. But again, if you've carried out a genuine redundancy, although it's not a technical defense to that claim, it is going to very helpfully assist you in responding really to any claim. Now that's going to make a whole lot more sense when we actually talk about what a genuine redundancy is. So let's jump straight to that. Sophie, walk us through what is a genuine redundancy.
Thanks very much, James. So look, in order to be a genuine redundancy within the meaning of the Fair Work Act, there are essentially 3 key criteria that you need to meet. So firstly, the employer must no longer require that person's job to be performed by anyone due to changes in the operational requirements of the business. Now, secondly, the employer is also required to comply with any modern award or enterprise agreement obligation to consult with the employee about the redundancy. And then finally, there needs to be no reasonable opportunities for redeployment of the employee in the employer's business or any of its associated entities. And if we fall down on any of those 3 criteria, then essentially you run the risk of the dismissal not being considered a genuine redundancy and an employee potentially having jurisdiction to bring a claim for unfair dismissal. So if we break down those 3 criteria, now the question of whether or not a person's job is actually no longer required to be performed by anyone is obviously going to depend on the relevant facts of each case. And for that reason, advice should always be sought prior to commencing any redundancy process. But generally speaking, a job will become redundant when the employer no longer desires it to be performed by anyone. So essentially that means that the dismissal isn't going to be due to any personal act or fault of the employee who's being dismissed. It's purely on the basis of some sort of change to operational requirements. And in terms of, I guess, what those changes could be, that mean the job is no longer required, as James sort of ran through earlier, it's generally things like a decline in business, which might require a reduction in labour costs. It could be a machine being available to do the job performed by employees, or it could even just be a restructure of the business to improve operational efficiencies, and that you've determined that position is just no longer required to be performed. Now, in terms of your consultation obligations, all modern awards contain what's called a model consultation clause, which relates to major workplace changes. And in summary, these clauses essentially require employers to notify employees of any definite decision to introduce major changes that are likely to have significant effects on their employees, such as the termination of their employment, obviously. Now, under these consultation obligations, employers are required to give notice and discuss the proposed changes with any affected employees and their representatives, such as a union, for example. And they're also required to provide all relevant information about the changes to the employees in writing. And then finally, they're also obviously required to consider any matters which are raised by employees about the changes before they actually go ahead and implement that decision. Now, one thing to note is that even though there is actually no obligation technically to consult with employees who aren't covered by a modern award or an enterprise agreement, we do generally consider it best practice to do so. On the one hand, you may well be that you're unsure whether or not your employees are covered by a modern award, but even if you are fairly comfortable with it, it is always considered most prudent to consult with them regardless as a means of mitigating any future risk of claims, as James has just gone through with you. Now, turning to the concept of redeployment. Redeployment essentially requires, where reasonable, that an employee whose position has been identified as redundant be placed into another job in the employer's enterprise or an associated entity as an alternative to the termination of their employment. And this is obviously going to vary on a case-by-case basis as to whether or not there are any opportunities for reasonable redeployment. So it will often require a bit of investigation on your end as to whether or not there are any possible job vacancies, and also obviously conducting an assessment of the suitability of any available positions to the relevant employee. So that question of whether or not it's going to be reasonable to redeploy an employee will always very much depend on the relevant facts and circumstances of any matter. Now, putting these kind of three criterion into practice, the next stage we're really going to go through in this presentation is what we recommend as kind of your three-step fail-safe redundancy process. Now, assuming that there is a genuine redundancy situation, the first step of the process is always going to be to warn the relevant employees. And this will typically involve inviting them to an initial meeting where you will basically explain to them that due to whatever the changes in operational requirements are, that the business is considering making their role redundant. Now, it's really important to stress that at this point, there is not a concluded outcome, and the employee is simply kind of being notified of the possibility of the redundancy, okay? And following that initial warning meeting, you should also issue a letter which actually invites the affected employees to a formal consultation meeting to discuss the proposed redundancy before the decision is actually implemented. Now, in terms of that invitation, we do generally recommend giving employees no less than 24 hours notice of the meeting, just to make sure that ultimately your employee is going to have ample time to prepare for the meeting and also to arrange a suitable support person if they do want to have someone present with them during the meeting. Now, the next step in the process is to hold that formal consultation meeting with the affected employees. And to be honest, if you take anything away from today's webinar, this really is the most critical step of the whole redundancy process, and it's often where a lot of employers will go wrong. Now, the main purpose of this consultation meeting is essentially to give your employees the opportunity to ask any questions that they might have relating to the redundancy process, such as, how the selection for redundancy is going to work. And it's also an opportunity for them to put forward any suggestions they might have as to how they could avoid the redundancy of their role. So typically, suggestions might be things like them taking some reduced work hours on a temporary or permanent basis. It could be considering some job share arrangements, or even just taking some accrued leave to try and ride out any downturn in the business, obviously depending on the relevant circumstances. Now, as we noted earlier, there is also obviously an obligation to consider redeployment as an alternative to redundancy during this consultation process. So any alternative positions should be conveyed to the employee during this meeting. And if no vacancies are available, then you just need to communicate that to the employee during that consultation process. Now, once again, I just have to impress that it's really crucial that no outcome or indication of the decision should be expressed to the employee at this stage. So generally, you'll just close the consultation meeting by confirming that you're going to go away, consider any matters which have been raised by your employee, and that you're going to come back to them and deliver the outcome very shortly. And then finally, the last stage of the process is obviously the communication of the outcome. And if following a fair procedure, the role is made redundant, then your employees should be called to a final meeting to confirm the outcome of the redundancy process. Now, in terms of the structure for that meeting, we generally kind of recommend recapping the process to date, outlining any alternative options you've considered and explaining why you deem them inappropriate, and finally confirming the termination of their employment on account of redundancy. Following that meeting, you should also make sure that you do send your employees a letter confirming the outcome and set out any final entitlements which will be owing to them upon termination as well. And on that note, I'll hand back over to James to walk you through the different entitlements which may be payable on termination on account of redundancy.
Okay, so ordinarily your permanent employees are going to be entitled to a redundancy payment, which is a separate payment once they've been with you for 12 months. And you'll see then in that table that we've got on the slide there, that their redundancy entitlement really depends on how long they've been with you. So it goes all the way up to 16 weeks when they've been with you for 9 years, but not 10 years. And it actually drops back down to 12 weeks once you've got an employee with 10 or more years service. The reason for that is that in all states and territories, once you've got 10 years service, you're going to have an entitlement to long service leave. So the idea there is that the employer is going to be paying the long service leave as well at 10 years. So they can drop that redundancy pay. So very much depends on how long someone's been there, but this is the general entitlement. This redundancy payment is something that they are paid in addition to notice of termination. So an employee might have a notice period in their contract, or otherwise the Fair Work Act sets out some minimum notice periods that at a minimum the employee will be entitled to. They will also be entitled to their annual leave, and they will also, if applicable, be entitled to long service leave, and that's different in each state and territory as to whether or not they're entitled to long service leave. So it's not just this redundancy pay entitlement that they'll get. So if you've had an employee who's been there for, say, in between 2 and 3 years, they'll get their notice, they'll get a 6-week redundancy, they'll get their annual leave paid out as well. You may find that you have to pay more than what's in that table there, and that would be if you had a workplace policy which offered, had an entitlement that was greater than what's in the table there. They're not very common, and you'll certainly know if you've got one. But generally speaking, this is what employers are up for. There are, of course, some exclusions to the obligation to make redundancy pay, and we'll walk through them on the next slide. So casual employees don't get paid redundancies. So if you were going through this process of a redundancy with a casual, it's more simple because they don't effectively have an ongoing expectation of work and a role that you're getting rid of. Their employment terminates at the end of every shift, so they don't get that additional entitlement for the redundancy. If you are a small business, you don't have to pay a redundancy. So a small business is fewer than 15 employees in your business and any related entities. So you would still have the notice, you'd still have to pay notice, you'd still have to pay annual leave and maybe long service leave, depending on how long the employee had been there. But what's in that table on the previous slide, you're not going to have to pay as a small business. And then the only final thing to note, I suppose, is that some modern awards like to complicate things for everyone, and they have their own specific industry-based redundancy schemes, and they'll be a separate entitlement to that table which we've shown, and those are the awards set out on the slide there. But the very vast majority of employers, other than small business employers, are going to be complying with what's been set out in that table. It is possible where you, for example, have a significant, say, redundancy liability to your employees, that you can make an application to the Fair Work Commission where you ask to be relieved of the obligation to make that redundancy payment. not very common that employers are successful in asking for that, but it's possible, it's open to you. So that's just something to consider. The types of things that might assist you in that is if, you know, you're paying a whole heap of other very generous benefits to employees, and you might ask the Fair Work Commission to relieve you of the obligation to pay that statutory redundancy. But the process of making the application can be costly as well. So a lot of the time businesses that can't afford to pay the redundancy, and that's why they want to make the application, probably also struggle to make the application on a cost basis as well. But that's certainly something to consider, where it would be a real hardship for the business to make the payments. So that ultimately wraps up the risks, the process, and what you're up for. So we're hoping that's been helpful for you to get an understanding of what's involved and things for you to think about if you are contemplating at this stage going through a redundancy process. We'll come to questions in a minute. Before we get there, just wanted to mention that we do have a comprehensive and free guide on hiring and inspiring your employees. It's a guide we've prepared which sort of talks you through everything in relation to what you need to know about hiring employees, but also a lot of tips and traps that employers come across during the employment relationship, including things like how to actually manage people and all the sorts of entitlements that you might find yourself up for as an employer in Australia. So I encourage you to download that. We also have some upcoming events. If we jump through to the next slide. So sponsoring foreign workers in your tech business, specifically aimed at tech businesses, but also very helpful for anyone who's considering sponsoring foreign workers. They'll certainly, you're not excluded from that if you're a tech business, but it'll be extra helpful if you are. Yeah, look, we'll walk through what you actually need to know if you are thinking about doing that. A lot of people talking about a significant shortage of workers at the moment in this economy. So now that borders have opened up, yeah, a lot of businesses now actually thinking about looking overseas for their talent. So that'll be something which can walk you through everything you need to know about that. We'll jump through now to questions. Sophie, you've had a look at the questions. You want to?
I have. Thanks very much. And look, we've had quite a few come through, so we'll try and get through as many as we can. And now the first question that we've got, James, is how do I pick which employees to select for redundancy?
Okay, yeah, question. So this might come up in a situation where you've got, let's say you've got 10 people performing the same role, and you need to get 10 roles down to say 5. So 5 people are going to lose their job, 5 people are going to keep their job. Typically, is the approach you'd take there. So you've got to identify the 5. Now, how you pick the 5, you can effectively put in any criteria that you like, as long as it's not unlawful. Now, what I mean by that is if you were to say we picked the lowest performers, that would be okay, because that's a reasonable basis to effectively choose and discriminate. But an unlawful criteria would be doing something like, well, who's taken the most sick leave? We'll get rid of them. You know, who's a working parent that, you know, sometimes has to finish up early? We'll get rid of them. And then obviously the more very obvious type of discrimination instances you might see, you know, people of certain religions, age, race, gender, all of those types of things. So they're all the unlawful reasons to pick people for redundancies, but the reality is you can pick anything you like. So even if you pick something like the people who were most recently joined will be the first to leave. That's a common one, and that also means you're paying the lowest amount of redundancy because you pay more the longer someone's been there. You might make a combination of things, a combination of people who are the most expensive and the least effective, or the most recently joined and most expensive. That'll save your business the most money. So anything you like is the criteria you can apply, as long as it's you can apply as long as it's not unlawful.
Great, thanks very much, James. Now, the next question we've got is just in relation to a change in employing entity. So the question is, how are employee entitlements treated or dealt with if the structure involves establishing a new employer within a group and the employees are then employed by a different entity?
I see. So if you're ultimately redeployed to your new entity, in that instance, there's no termination of employment, and that if they're moved within the same group, they're effectively transferring their employment to the new group, and there'll be no redundancy payment. So those payments, paying out notice and paying out the redundancy, are only payable on termination. And that's the same. So if you, for example, were to say to an employee, let's say you had an employee earning 150 grand a year, but you said, well, your role's gone, but we do have a vacancy in this role, but the role is $50,000 a year. Now, they don't have to accept that role, but you can offer it to them. And if they said, you know what, it's just important that I keep some money coming through, I'll take it. There's no termination. And notwithstanding that role is redundant, their $150,000 role is redundant, they're just transferring their employment through to a lower paid role, but they remain employed, so there's no redundancy. So you have to be terminating their employment in order for that entitlement to crystallise, and a transfer within a group wouldn't be a termination.
Great. And here's a nice quick one that we can probably knock over. In terms of the 15 employee mark, what qualifies a small business? Is that 15 employees or 15 full-time equivalent employees? I have several casuals, but under 15 full-time staff members.
Okay, so yeah, it relates to permanent employees as a starting point, but it can, so do you have fewer than 15 permanent employees? But if your casual employees are employed on a regular and systematic basis, then they can count. So as with all things employment law, it's unnecessarily complicated, and it's not really a strict case of 15 in terms of a head count. But generally speaking, they're concerned with permanent employees or regular and systematic casuals. So if you add them all together and you're under 15, you're a small business. But if they take you over to 15 or more, then you're going to have to pay the redundancies.
I think that's quite a common issue that does come up, where people have long-term casuals who are effectively working the equivalent of full-time or part-time hours.
It's the subject of disputes in the Fair Work Commission as well. This being a small business has consequences for unfair dismissal claims as well, and often there are sort of preliminary decisions by the Commission as to whether or not you actually are a small business before the substantive matter can actually proceed. So it's a concept that gets litigated a little bit, but there is some grey area in there, and it can actually be quite a complicated number to arrive at.
Absolutely. Now, the next question we've got is in relation to when an actual claim is brought. So if an unfair dismissal claim was made and the employee was ultimately successful, are you able to give us a bit of a rough idea on what the likely costs would be to the employer in that scenario?
Sure. So there are probably two types of costs involved. The cost of actually just running the claim, which hopefully is our fees, if you guys are members here, which, for an unfair dismissal claim, it's a significant range depending on where it goes. The cost in terms of what you can actually be awarded or what you have to pay the employee, assuming you lose the claim, there's a maximum payment you'd have to make of 6 months. So in the Fair Work Commission, for an unfair dismissal claim, damages are capped at 6 months. And so, so look, for an employee, that means given the high income threshold, they're capped at 81,000. That's if you lose hands down and terribly, and it's very unlikely that you'd ever have to pay the 6 months. And so with that in mind, look, the very vast majority of unfair dismissal claims settle as well. They all go to mandatory conciliations. And look, typically because there are legal fees involved in proceeding through to the Fair Work Commission, that's a great incentive for most employers to settle the matter, because you can settle them for relatively limited amounts. So it's often more cost effective to pay these claims out than it is to run them, even if you're going to win them. So yes, it's not the most significant liability. And typically where you've already paid someone a redundancy in the context of termination and then they go and challenge it, the fact that you've already paid them a redundancy would be taken into consideration in relation to what they might actually be awarded if they win at the commission. So if that does happen, if you are a member, obviously just chat to us and we can walk you through any number of options on strategy for how you might respond to those claims, because they're typically more concerned with the commercial realities of the claim rather than they are with your actual legal position. So it's important to chat to us about that.
Thanks, James. And on that same line of thinking, as far as any potential sort of reduction to the amount that could be awarded to an employee, one of the questions that we've had come through is whether or not an employee can refuse redeployment and choose a redundancy instead.
Yeah, so they can, is the answer. They're not obliged to accept a different role. In a different context, in relation to transfers of business, when a new company is buying your company, there are exclusions where if they are offered a role with the new company who comes in and buys the old company where the employee is currently employed and they refuse to take that new role, and that role is the same as the one they're currently performing, then there is a mechanism under the legislation to say that the employer doesn't have to pay the redundancy. But in absent there being some purchase of the business or transfer, the position here is that they don't have to accept another role that you put to them. So then it would be open to them to say, I don't want that, I want my redundancy. Where that gets maybe a little bit grey is where you're only making very minor tweaks to someone's role, and in which case it would probably be open to you to argue that it's not even a redundancy, and that really all you're doing is just making, tweaks, small changes to a role. The role's just evolving in a very normal way, but you will often find that once you get sort of you're making significant changes to the fundamental nature of the role, that's when you'll sort of, I guess, tip the balance and will now meet the threshold of a redundancy. So again, a little bit of grey area in that one, but strictly speaking, no, if it's a different role, they don't have to take it.
Absolutely. And I think that kind of ties into another question that we've had here in relation to whether or not the replacement of an employment agreement which lowers the wages and responsibilities between the employee and the employer is considered a dismissal on account of redundancy. And I think, as you've pointed out, James, it does really depend on the extent to which that remuneration and the duties are actually altered ultimately, doesn't it? Yeah,
that's right. And look, when you're tinkering with key elements of the role, you're more likely to be in a redundancy. Now, a salary is a key element of someone's role. So if you were to say, oh, look, you're doing all the same things, but we're just taking 10 grand off your salary annually, you'll certainly have a redundancy because it's a very significant change to the role. And anytime you're really reducing it, it's probably going to amount to a getting rid of the role that they were performing and creating a new role at a lower salary. So yes, you do have the option, though, in that circumstance, if you were to sort of forget redundancy and just be saying to someone maybe they're not performing and that it's actually better that they go on a lower duties, lower pay. You could be proposing that as an alternative to being terminated for poor performance, but you'd want to have your ducks in a row in relation to the otherwise termination that you were going to effect for performance. But yeah, taking away key aspects of the role, including things like salary, almost always going to be and meet that threshold of a redundancy because the role is gone.
Yeah. Absolutely. And on that same sort of train of performance managing someone out of business, we have had a question through around how to performance manage someone if you can't use redundancy. We won't address that here today, but we do actually have a webinar on ending employment generally in a few weeks. So keep an eye out for that one. So we might finish with one last question, and this is one that actually quite frequently comes up, as far as whether or not you can re-employ an employee that was made redundant, and alongside that as well, how long you should generally wait to actually re-employ for a position that's been made redundant.
Sure. Okay. Yeah. Good question. So there's no hard and fast rule here. There's no set timeline that says you must wait a certain amount of time. The reality is that when you're at the point of making someone's role redundant, if at that stage you don't have any intention to immediately rehire, then that's okay. You've got a redundancy. If, say, even within 3 weeks of having terminated someone's employment, there was a fundamental change that then required you to re-advertise that role, and we might have seen these things, during COVID, for example. So where industries were shut down, businesses said, well, there's no work, we're going to make you redundant. If 3 weeks later, and so they went through the process, they terminated someone's employment. If 3 weeks later the industry was then allowed to reopen and the business got operational again, well, they'd absolutely be entitled to reach out to that employee and say, hey, your role's still right here and you're welcome to come back to it. So something, in a sense, something needs to change in the intervening period, and you don't necessarily even have to go straight back to the employee who was performing that role, as long as when you did make them redundant, it was genuine. Of course, what the risk here is that if, for example, you do make someone redundant and then very shortly afterwards you rehire someone else into that role, it paves the way for that employee who's lost their job to argue that this was never about a restructure where you got rid of this role. This was for some other reason. So it's not a genuine redundancy. And they might say, well, this is a discriminatory because you clearly still need the role. You've just rehired it. But if you can demonstrate that, no, when we made you redundant, we actually didn't need the role, then you'll be in a really good position to respond to that claim. So yeah, look, no hard and fast rules there. But you want that sort of intervening factor to demonstrate why it was the right thing to do to make them redundant at the time and why something's changed.
Absolutely, makes sense. And I think another common question we do get is whether or not they can just wait the 21 days where they can make a claim for unfair dismissal. And I think it's quite important to note that obviously if you do rehire someone in that position that's been made redundant just outside that 21 days, it's never going to look good. And that may be one of those very exceptional circumstances where an extension of time could be granted to make such a claim. All right, well, look, that's super helpful. Thanks very much for going through those questions and answers, James. Just a few last housekeeping matters. Now, for those of you who aren't already members, LegalVision has actually recently moved towards working with our clients through a subscription model. And our product, LV Connect Pro, is essentially designed to provide you with all your ongoing legal support for business as usual needs. So it includes unlimited advice consultations, document drafting, document reviews, and Australian trademarks. And certainly, if you are in a position where you are considering making some redundancies in your business, LV Connect Pro would give you access to things like, written advice around our recommended process, template letters, so invitations to consultation meetings, confirmation of outcome letters. And although we don't actually crunch the numbers for you, we can also certainly assist with giving you an idea of what you might be up for in terms of final entitlements and, of course, any exclusions from the obligation to pay redundancy pay. Now, as webinar attendees, you are all also welcome to request a complimentary consultation today if you do want to discuss with us how we can help you with your redundancy and restructuring needs. So if this is something that you'd be interested in, feel free to leave your contact details in the survey that will pop up once this webinar ends. Or alternatively, you can, of course, email us at reply@legalvision.com.au and register your interest there. So I think that wraps everything up for today. Thank you, everyone, for joining us, and look forward to seeing you on our next webinar.
Thanks, everyone.